first case to come before the court is State of Ohio v. Rachel Maines. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know as I'll be keeping track of the time. Arguments are being recorded. When you present your argument, please introduce yourself, stay behind the podium, and keep your voices up. You should not use the names of children or victims or minors in your argument, should that be relevant to your argument, and you can refer to those folks as the children or other generic terms. We've read your briefs. We're ready to proceed when you are, and I would just ask Appellant's counsel, would you like to reserve time for rebuttal?
I'll reserve 5 minutes.
Okay, very well. Then we are ready to proceed when you are.
Thank you. My name is James Reed. I'm the attorney for the appellant Rachel Maines. I wasn't the trial counsel, but I was appointed by the court to represent her for appeal purposes. And as the court indicated, you've read the briefs. It's not that complicated of a case, but it's kind of an unusual fact pattern, I think. It involves the issuance of a protection order that apparently they had a hearing, but it wasn't filed for 3 or 4 days, and then my client was accused of violating it. The order itself was never presented during the jury trial, and it wasn't until after the verdict came in and the sentencing hearing, the same day as the sentencing hearing, defense counsel submitted or made a motion to renew a criminal rule 29, arguing that she couldn't violate a protection order that hadn't been previously time-stamped and filed. I've always been of the impression and the understanding that a trial court or any court only speaks to its journal entries. So if it's not time-stamped, the initial argument would be it's not a valid order, and the court should have taken that into consideration in ruling on the motion.
Counsel,
the visiting judge.
Counsel, let me ask you a question. You know, back in the old days when I was on muni court and a trial judge, somebody would come in and I would tell them, you know, you have to stay away from the victim. So you're telling me that unless I filed that and until it got filed, if they went out of my courtroom that day and beat up the victim, then that's permissible, that it wouldn't be a violation of my order?
I've obviously been present for a lot of those
No, you haven't.
those hearings, and I know that's standard procedure. I don't know if this is, and I understand that, you know, judges make those oral pronouncements to the clients, and they acknowledge it on the record. I don't know if that happened in this particular case, because it was a little confusing to me when I was looking at the procedural history, because there's a DR case number, and there was an ex parte protection order, and then there was a full hearing, I think, on March 23rd, and then the actual order didn't get filed till March 27th. I can only speak from my personal experience. I don't know if this is COVID related or not, because back in the old days, when you would appear in front of a municipal court judge, you know, they'd write it on the file and they take it right to the clerk's office and get time stamped, and it was almost contemporaneous with the oral pronouncement. Nowadays, you know, sometimes the judges are on Zoom from home, or the prosecutor's somewhere else, and then the court secretary and the court reporter. Sometimes it takes, I get orders a week or 2 weeks after the fact, and I think it's in part because I think it's more efficient sometimes to do things on Zoom from a practical standpoint. You don't have to transport prisoners. You can do your arraignments and pre-trials a lot quicker, and it speeds up the call day. But the inner workings of the court don't work as fast as if everybody was present in the courtroom and you just walked it down the hall and got stuff filed. I don't know if that was a cause in this case or not, but I would still indicate that my client, Rachel Maines, even if you look at the alleged violation, of the protection order. What she did was, I believe it was a Facebook post to a third party. I don't think she was willfully violating any court order. It was just, hey, I've got some of his stuff, he's got some of mine, can you contact him? And, or I don't even know if she asked him to contact outright. It just said, can you check and see if he's available to transfer this property? So I don't think it was malicious or intentional or anything on her part. You know, they had a jury trial. If I remember right, I got 2 appeals today. I don't recall if there was a jury question on this one or not, but in any event, you know, the argument I set forth in the brief was primarily that if it wasn't time-stamped, it wasn't enforceable against her. And that would relieve her from the violation.
So counsel, if I understand correctly, you're arguing that the filing and the timestamp is what converts the order into a real order. It's the magic that turns it into something enforceable. And until that happens, it's not an enforceable order.
I've been proceeding under that presumption for over 35 years now, that it has to be journalized. Just like this court, if you don't have the 4 things for a final appealable order, it's not a final appealable order, you know.
Well, I think there's a difference though between saying something has to be journalized and saying that it doesn't have any effect until that journalization takes place, you know, so, but I get what you're saying. Thank you.
Okay. Let me see if I have anything else. I mean, like I said, it's a fairly straightforward issue, I believe, and I don't really have anything more unless you have some questions for me.
Okay, then you will have your full time for your rebuttal.
Okay, thank you.
Thank you.
Good morning, Attorney Jennifer Roberts on behalf of the state on the appeal regarding this Rachel Means conviction. Counsel stated this case is relatively straightforward. It's an issue of whether or not Ms. Means violated the protection order. In follow-up to the court's question to counsel, this was a consent agreement that all parties were present in the courtroom, signed the day of the entry, acknowledging that they read and reviewed and agreed to the terms of the protection order. That protection order was then signed by the magistrate as well as the judge on the same day that everyone appeared in court. Everyone left that courtroom on the day that they were there. And that's all in the admitted exhibit 2, which is the certified copy of the protection order for the court's review. With respect to the argument that that protection order doesn't take effect until it's time-stamped by the clerk, they're sort of arguing both things in the brief, is that the ex parte terminates when the full protection order is granted. They're saying the ex parte is not in effect that weekend, but they're also saying the full hearing is not in effect that weekend. They are literally wanting to have their cake and eat it too, and do talk out both sides. The state would argue there's case law that indicates when the judge takes that file to the clerk, it's being filed. Why the clerk sat on it, I have absolutely no idea. But it is clear through the exhibit that was admitted into court, it was everyone's intention for that protection order to be filed and timestamped that day. Why else would it have been walked from the magistrate to the judge for signature? So the state's going to argue that that protection order was effective when it went to the clerk's office for filing. Why it sat there, no one knows. If the court follows the argument made by appellate counsel, you're going to have a lot of situations where people leave the courtroom thinking they're protected by a protection order because it's been a consent agreement agreed by everyone, signed by a magistrate and a judge, and they received that order when they left that day. Protected if the clerk doesn't file that for whatever reason. Maybe the criminal clerk or the protection order clerk had left that day and sat on their desk until they returned. I'm not sure. But I can say, when you review Exhibit 2, I don't believe there's any indication or any inference made that it was not filed that day when it was taken to the clerk's office. It was signed by everyone. Everyone knew what the terms of that protection order were. It should also be noted that the argument that counsel's raising here today was never raised in the trial court with respect to the timing of that judgment entry. That was never brought up in the trial court until they filed the post-conviction Rule 29 on the day of the sentencing hearing. That issue was never brought up to the trial court for the trial court to have reviewed until that time. And I believe it's my understanding through the review of the judgment entries that this court has indicated that that judgment entry denying that post-conviction release is not up on appeal right now. So I'm not sure, I think we're making a bigger issue out of an issue that might not even have been an issue to begin with, if that makes sense. With respect to the sufficiency and the weight of the evidence, as the court's aware, the jury trial heard that evidence. They found that there was sufficient evidence. Counsel noted in his argument that Ms. Maines didn't knowingly violate the protection order, and that's not the standard in this case, as the court's aware. The standard with respect to violation of protection orders is recklessly. The protection order was very clear that in the order, he's not to have contact with Ms. Maines, but in addition to that, he's not allowed to have anyone have contact with Ms. Maines that he's not allowed to have. When he reached out to a third party and asked them to make arrangements to meet with the house, he's not allowed to do that to Ms. Maines, therefore the protection order prohibits him from doing that to a third party. He's not allowed to have any communication or elicit anyone to have any communication that he's not allowed to have. The jury did find that there was, beyond reasonable doubt, evidence that was presented that he did recklessly violate the terms of that protection order. Also, with respect to the arguments, sorry, I stepped away, I forgot something. With respect to the arguments regarding the filing of it, if you review the revised code 291927, when it was modified with respect to not requiring the state to prove service of the protection order, just knowledge of it, Section D, in prosecution of violation, it's not necessary for prosecution to prove the protection order or consent agreement was served upon the defendant if the prosecution proves the defendant was shown the protection order or consent agreement, or a copy of either a judge, magistrate, law enforcement informed the defendant the protection order and consent agreement had been issued. That occurred in this case. He was present on that day and he was informed and consented to that agreement and signed said agreement, acknowledging the terms of the agreement. And so to argue now that Ms. Maines didn't know that there was a protection order and didn't know what was required of her to have no contact with the victim, I just think is, an insincere argument. She left that courtroom that day knowing there was a protection order issued and signed the protection order consenting to its terms, therefore acknowledging the terms of the protection order, and went out the very next day and violated that protection order. So I believe that's the crux of the state's arguments. If the court has any questions, I'm happy to answer those for you.
Hearing none, thank you, Counsel.
Thank you.
Mr. Reed, you will have your full 5 minutes for rebuttal.
Yeah, I just hopefully won't take more than a minute or two. The only thing I would say in rebuttal was, I think whether the ex parte hearing was March 23rd and the trial or the journal entry went on March 27th. I believe at the jury trial that was held, the trial counsel, I don't think the actual exhibit was entered until after the fact, which is why he filed the Rule 29 motion after the jury verdict. And part of trial counsel's argument, as I recall, was just a deputy Summit County Sheriff deputy testified he went on leads and some other computer system and verified that there was apparently some language there. And I guess the argument from a defendant's perspective would be that should have been admitted, there was no foundation laid, and the journal entry itself wasn't submitted, I believe, until after the fact. I was trying to find that in the brief I wrote, but I don't recall 100% when the actual timestamp journal entry was brought forward. My recollection, it was not presented during the trial. If I'm wrong about that, I apologize, but that's the only thing I would say in rebuttal, unless you have a question about that. Okay, thank you.
Hearing none, thank you so much. Thank you for your presentations. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of the decision to you on the day that it's released, and it will also be posted on the Ohio Supreme Court website.